Good afternoon and welcome to this Corney and Lind webinar. My name is Joseph and I'm with the Business Development team here at Corney and Lind, and today's webinar is entitled Church Constitutions and Governing Documents, Are They Relevant for Current Times? Now, before I hand you over to our presenters today, I'm just going to go through a couple bits of housekeeping. Firstly, a recording is going to be made of this presentation, so if you check back on our site halfway through next week, you'll be able to see a copy. So if you get pulled away from your desk today, then yeah, you'll be able to check a copy of it on our site there. If you have any questions, there's a chat box on the bottom left-hand side of your screen. Do feel free to enter your questions in there. Be aware that everybody will be able to see your questions, so yeah, do keep personal information out of it if possible. So yeah, just to hand you over to our presenters, today's presentation is being presented by Kathleen Watt, who's a senior associate here, and Jessica Lipset, one of our associates. So yeah, both of them have a huge amount of experience in constitutions, governing documents, and issues that relate to churches and charities. So I'm going to hand you over to them
now. Thank you, Joe. It's my pleasure to be speaking to you today. My name is Kathleen, as Joe has introduced. My primary areas of practice are in not-for-profit and charity law. I also do some commercial work, and I work in estate and elder law as well.
Thanks, Kathleen. And my name's Jessica Lipset, and I'm an associate in the Corney and Lind litigation team. I primarily work with not-for-profit and charity clients of some description, including our church and institutional clients, primarily in dispute-related matters. Now, in terms of what we're going to be covering in today's webinar, I'll just give you a brief overview. So firstly, we'll be looking at what are your governing documents, so what documents are we actually talking about when we use that term, the importance of those documents and what they should contain, some key issues that we tend to come across in our practice relating to your governing documents, and then we'll be talking through a couple of case studies that highlight some of the issues that we'll be raising today. So now I'll just hand over to Kathleen to address these first couple of points.
Thanks, Jess. So, as you might think, governing documents will have a different name depending on your structure. We've just set out 4 different usual structures that you might have heard of before and what the governing documents might be for each of those structures. We do note that they do have different names sometimes depending on the state or territory which you are in, but generally speaking, for unincorporated associations, they usually have a set of rules. It could be called a constitution, or they could be guided by some constituting legislation, church or canon law. An unincorporated association, just to clarify, is any group of people with a common purpose. So they don't have any legal structure or entity per se, but they can come together under a constitution for the purpose of carrying out activities for the advancement of a charitable purpose. And of course, we're speaking to ACC churches, so your charitable purpose would be the advancement of religion. The next level up, if you like, is an incorporated association. Now, they are legislated by the association's legislation. So, incorporated associations legislation, depending on your state or territory. So, these are really largely member-driven models. They're pretty uncommon for ACC churches. But the type of governing documents that you would have is usually a statement of purpose and rules, or articles of association, or in fact a constitution. And so the most common structure that we see with ACC clients is a company limited by guarantee. Usually the governing documents would be called a constitution. Historically they have been known as articles of association as well, but generally we're talking about the constitution. For trusts, it'll be a trust deed, including any variations to the trust deed. And in particular, we should mention this would include a schedule of trusts. So if your church has a charitable property holding trust, the schedule of trusts is annexed to the transfer that was lodged at the time that the church purchased the property. So those terms, although they're attached to the transfer, they actually form the governing documents for the trust. So we can probably assume that governing documents are fairly important, but I'm just going to speak to why they're important from a regulator's perspective. And the Australian Charities and Not-for-Profits Commission is the national regulator for all charities in Australia, and ACNC for short. Registration with the ACNC is required for a charity to be entitled to its tax concessions. So if you're not registered as a ACNC charity, the ATO won't allow you to have income tax exemption, GST concession or FBT rebate. So that's really essential. If you have a structure that's actually capable of registration as a charity and it's not so registered, you should be seeing one of us to get that in order. But also, once you're registered with the charity, you have, so with the ACNC as a charity, you have to keep your governing documents on the ACNC register, and they need to be updated from time to time as and when they're updated by the charity. The ACNC describes governing documents as the formal documents that set out the way the charity operates, its rules and its purposes. Generally, bylaws and regulations do not need to be uploaded to the ACNC. We'll talk a little bit more about what a bylaw or regulation is as opposed to governing documents later on. These are some of the things that your governing documents should cover and usually do cover. So your charitable purpose, not-for-profit nature, use of income and assets, governance powers, duties and processes, decision-making, consultation and control, records, dispute resolution and alterations. So this is just a bit of statistical information that came out of the Charity Compliance Report of 2017 that the ACNC prepared. In 2017, almost 1,700 concerns were raised about charities. We're not talking just about churches here, but all charities in Australia. Out of that, 202 charities were investigated and 82 investigations finalised. 26 of those cases, in those cases, the charities were deregistered, and 16 of them entered into compliance agreements with the ACNC. So you can see the ACNC's not shy of exercising its powers to investigate charities where they're not in compliance with the ACNC Act, and we'll talk to how governing documents are relevant to that shortly. The charities that were subject to the investigations controlled over $5.9 billion of charitable assets in Australia. And the most common theme coming out of that report was poor governance.
Sorry if there's any noise, we've got some construction going on next door. We'll see if we can get to pause for a short while.
As you can see on the slide, the importance of governing documents, again, the ACNC report found that poor financial controls, inadequate due diligence, and a failure by the charity's responsible persons to act in the best interests of the charity were the most common issues identified. And so they're going to be the focus for the ACNC in 2018. Sorry about that. So from a regulator's perspective, these are the things they're going to be looking at, and it's important that you consider this and address this in your governing documents. So we'll explain a bit more in the following slides. But the next big regulator that you need to be aware of course, is the Australian Tax Office, as it will review and consider your entitlement to tax concessions. So Section 5050, subsection 2 of the Income Tax Assessment Act requires that in order to be exempt from income tax, a registered charity must comply with all the substantive requirements in its governing rules, and it must apply its income and assets solely for the purpose for which it is established. So as you can see, it is important to understand what the governing rules are. It's not just a document that's agreed to at the establishment of the charity and put aside until there's a dispute, although that is sometimes what happens with some of our clients. We really need to be aware of what the rules are and ensure that the charity is complying with those requirements, and ensure that the actual purpose for which the charity has been established is what the income and the assets are being used for. So I guess where we draw the connection between the ACNC and the ATO rules and regulations and what needs to be in your constitutions is where you see how are we going to control who the members and directors are. So what's the essential criteria for those controllers of the charity? Are we going to be ensuring that they're complying with the requirements of the ACNC and the ATO in order to ensure that we continue to be registered as a charity, we continue to be embed to tax concessions? How do we ensure that the governors are accountable to the members? What mechanisms can we embed in the Constitution to make sure that the governors are being accountable? And can we draw the attention of the directors, for example, in the case of a company, to the governance standards of the ACNC? So a constitution is a really powerful document for being able to draw attention of the controllers to what's important for compliance perspectives, also to keep the directors and the board or the management committee accountable to the members, and embedding the essential criteria for the controllers of the organisation. Another thing to say is the governing documents are really essential for ensuring that the church maintains its philosophical purpose and control of its assets. So churches will often have other entities in the corporate group. There might be a care arm that's providing services to people, say, who are suffering from hunger, homelessness, that sort of thing. There could be schools or childcare centres or aged care homes that are associated with and established by the church. Each of these different entities will have its own charitable purpose, but it's often the intention of the church to retain the control over those entities to ensure the philosophical purpose for which they've established is maintained. And there's specific advice that we can give to that particular issue if you're concerned about that. But really what's important is the advancement of the Christian faith, particularly for a church. They're not losing sight of that when they've got all of these other organisations and entities running different activities for separate purposes. It can also be really important in terms of winding up. So what happens with the property, the assets of the church? Is it going to go back to the ACC, or is it going to go to a like-minded charity with similar purposes? So I've touched on some of the important things to be contained in the Constitution in the overall background that I've given, but I'll draw your attention again to the things that your governing document should definitely contain. They'll be on the slide in front of you. The first three, it's essential that you get these right. So what's your charitable purpose? Are you keeping that purpose? Are you using your income and your assets towards that charitable purpose? Is the company or the incorporated association or the trust, is it not for profit? That is profits that are being generated by the structure, are they being, for example, applied to the benefit of the charitable purpose rather than for the benefit of the members or directors? Now, it's really important that you understand that distinction. So your charity can be making a profit, but that profit can't be paid to the members or directors. It needs to be paid for the purposes for which the charity has been established, being the advancement of the Christian faith. Use of income and assets, similar requirements, and the winding up requirements are all part and parcel of that. So we're not going to focus on those things. We're going to go on to discuss the matters in bold and some of the key issues we've identified in terms of keeping your governing documents up to date. So the first one was governance duties, powers and processes. You might want to ask the question at this stage, who are the governors? Who are the governors of our church? And the ACNC would describe these persons as responsible persons. For incorporated and unincorporated associations, they're usually called the management committee. For companies, they'll be called the directors. For trusts, they'll be called trustees. So they're the persons with responsibility on behalf of the charity to make sure the charity is complying with the ACNC Act and the governance standards if they apply. Now, as governors, the management committee or the board can actually delegate some of the day-to-day operations to the management of the church. That may be your staff or ministry leaders or lay leaders that carry out those day-to-day operations. Governance is really about oversight. It's about providing strategy. It's about keeping the managers accountable and also making sure, as I said before, that the church is tracking with its philosophical objects. If you desire, it is possible to have your board take on a managerial role as well as a governing role, and that's usually the case in smaller churches where you don't have a separate board from the ministry team. What's really important is that you've just clarified what the role is for those different persons. And when it comes to complying with the ACNC governance standards, it's your board that must comply. I've noticed there's a few questions. Kylie, we will have access to the slides later on. They will be uploaded to the website. In relation to content questions, we'll save them for the end of the webinar, so I'll return to that later, but please feel free to ask questions at any time. So the question of whether ACNC governance standards apply will depend on whether you're a basic religious charity or not. In short, a basic religious charity has to be an unincorporated association. So if you're an incorporated association, company or trust, then they will apply to you. You will not be a basic religious charity. So in most cases they apply, and even if they don't apply, we consider them to be appropriate standards for basic religious charities to be, I guess, holding themselves to. It's just that you won't be you won't have the ACNC overseeing your compliance with those things. Now, there's a list of what the governance standards are there on the slide. The most important ones I want to draw out, well, they're all important of course, but accountability to members, that's one thing that we can really deal with in our constitution, and suitability of responsible persons. So we're going to speak to those things later on as well. Now, the duties of responsible persons are generally to act with reasonable care and diligence, to act honestly in the best interest of the charity, not to misuse their position, to disclose conflicts of interest, to ensure responsible management of financial affairs, and not to allow insolvent trading. So they're the types of duties of the responsible persons, and we can deal in the Constitution with how we select or appoint our responsible persons. I've mentioned accountability to members. We draw attention to that because it is important for complying, of course, with the ACNC governance standards. But we need to ask the question whether they are really contained in your constitution or whether they're switched off. Now, the reason for this is a lot of old constitutions refer to the Act when it comes to giving members the ability to, for example, call a general meeting, propose a resolution, or appoint a proxy so that they are able to actually vote at a meeting even if they're unable to attend. So these are all accountability measures that are generally provided under the Corporations Act for companies. But with the introduction of the ACNC, we've had the ACNC Act actually switch off a number of these provisions. And that is because they want to make it easier for some charities in cases where it's just not relevant or appropriate for them to have to hold an AGM once a year and allow members, for example, to call meetings or propose resolutions. But in most cases, we do recommend that you keep those accountability mechanisms. And so in order to be up to date with the times, you'll need to have those provisions, in our view, put into your constitution. So it's just a case of going through and deciding, do we want to allow members to be able to call a meeting? If so, what percentage of members are required to be able to do that? And can they appoint proxies? It's not enough, in our view, to be referring to the Corporations Act provisions because, as I said, they've been switched off. But generally, these mechanisms protect you in the long run because it's just a way of allowing accountability to the members and ensuring that. So there are a number of provisions that are relevant. We won't go through them in detail, but if you're concerned about whether those provisions apply to you or not, you should come and see us and we can give you advice on that. A particularly important one for accountability to members is holding an annual general meeting. So that's actually been switched off by the ACNC Act and the Corporations Act, but it's recommended as a means to staying accountable. Now, these provisions that I'm referring to as being switched off, they only apply to companies, but all of those mechanisms can be imported into the constitution of incorporated associations and unincorporated associations as well. There are different rules around incorporated associations. As I said, there's state legislation that applies, and that will just depend on which state or territory the church is established in. So your constitution should also consider delegation, authority and limitations. So this is in relation to how much can your board actually delegate. As I said before, it might be the day-to-day operations that they delegate to your ministry staff, and that's fine. But we do set out in our constitution the ability for the board to establish subcommittees and delegate roles and responsibilities to those subcommittees. Generally speaking, when it comes to managing those subcommittees, we recommend that you do that by setting up regulations. Regulations are passed by the board instead of being in your constitution. However, if you want the protection of rules being embedded in a constitution, then you want to make sure that it's in the drafting of the constitution itself. So the protection that I'm speaking about there is that, generally speaking, a member meeting would be required to amend the constitution. So again, you're going back to the members to say, do we want to keep this? Do we want to change it? It usually requires more people to sit at the decision-making table. If it's something that you want it to be flexible, you can have it passed by way of regulations. So limitations, that goes to whether you want the board's decision-making ability to be limited in certain circumstances. For example, we've had churches that want to say the board cannot make decisions in relation to real property, buying and selling, borrowing money over a certain limit, mortgaging real property, anything along those lines. So you might want to set particular limitations just depending on how much authority you want to give the board to make these decisions absent of membership approval. Now, we need to speak to the lifeline government appointment, discipline and removal. that's really about how do we manage difficult board members in the case of them becoming, I guess, separated from the interests of the company. If they're behaving in a way that's no longer in the interests of the company. It's really important as a process set out in your constitution for dealing with that and guard it so that you can guard against church splits. You can prevent deadlocks in the case of small boards and so that you can ensure that transparency is maintained about the process and the procedure. That's something that needs to be dealt with. It's also, I guess, a means to setting out how members can remove board members if they're not complying with the ACN's governance standards. Now that sort of thing can also be set out in regulations, which is, as I said, promulgated by board resolution rather than embedded in the constitution itself. Again, it's up to who you want to be in control of changing those. So there's a few matters raised on these slides that crosses over with the last slide, but basically the next thing is to talk about decision making, consultation and control. So when we talk about the controlling minds of a church or a charity, you need to look at who the board members are, as I said, management committee or the directors, and who are the members. Now, you can have different types of models when it comes to the membership. You could have a closed membership where the members are basically the directors from time to time, and if a person ceases to be a director, then they cease to be a member. That's something available for companies. It's not really available for incorporated associations because, as I said, that's a member-driven model. But that's what we call a closed membership. So the members are the directors. A narrow membership could be having the members as directors, but also having certain other persons as approved by the senior pastor being members. That's where you'd like to have a few more people, I guess, in consultation at the decision-making table, subject to someone having veto power. Again, that's more difficult to implement for incorporated associations, but more easy for a company limited by guarantee model. And the third type of a membership is open membership, where you're basically open to anyone over the age of 18, provided they accept the statement of faith of the company. So that's really where you want to bring on as many people as possible and give them an interest in, I guess, having a say in the company and their activities. Just need to remember that if that's the option you're going for, these people will have what's akin to a proprietary interest in the company. So they do have a say, and they should really be able to vote on changes to the Constitution and the appointment of or removal of directors. So that goes to members standing. What control do they really have? Can they remove office holders? Can they convene meetings? Those sorts of things can be set out and should be set out in the Constitution. If they can't vote on Constitution changes and they don't control the office holders, they may not actually be members. So they might be called members in the Constitution, but if you're removing all of those rights, they may actually be more congregation attendees rather than members themselves. So when the ACNC talks about accountability to members, they're looking for those persons that have the usual right to remove office holders and vote on changes to the Constitution. Now, financial controls, we've mentioned that already. Do you have to revert to the members in order to buy or sell land or borrow money over a certain amount? Those sorts of things can be embedded into the Constitution, or they could be passed by way of regulations. Due diligence. Have you embedded sufficient checks and balances for the appointment of members and directors, given that they're going to be making the decisions in relation to the charity. One example that we do use a lot in our charity constitutions for churches is to enable the board to pass regulations to basically set what the criteria is from time to time. So if there's a change, I guess, over time of what's important for your membership, the board can actually pass a resolution without having to go to the members' meeting. But this is one of the issues that we'll raise with someone when they're drafting a constitution. Is there anything essential that you want to make sure is part of the membership criteria and is not easily changed? If that's the case, then we put it in the constitution. So an example of embedded criteria for membership that we often see is that they've been baptised, that they regularly attend the church and they're willing to tithe regularly. You might even want to go a step further and have reference checks if that's something important, particularly where you're giving a lot of control to your members. And the same goes for due diligence with respect to the appointment of directors. What's the requirements there? Oftentimes we suggest that it's a requirement that your directors also be members. And so where you've got a well thought out membership criteria, if a director is required to be a member, they've obviously had to meet that criteria already. So they're the types of things we cover under due diligence. And turning to the last point, member discipline, cessation and removal. This is an important one, especially where you have disgruntled members that may no longer be acting in the interests of the charity. How are you going to deal with that, and how are you going to preserve the objects and purposes and make sure that you're able to move on? So there are basically two or different ways that a member could have their membership cease. So automatic cessation. So there could be certain situations in which there's no decision, it's just automatic because, for example, death is one. Obviously they're no longer a member at that point. And then removal is in a case where the directors have had to meet together and decide for these reasons this person is no longer suitable for membership. In the case of removal, we need to make sure that we have a just and fair process for removal to ensure that we're complying with natural justice. Otherwise, we may have an issue on our hands. So Jess can speak to that. She's got a case study of something that's similar to matters that we've dealt with in the past. So it's really important that you consider just how a membership could end and you deal with that. One example might be if you want someone's membership to cease for not attending the church, you need to think about how you define attending the church and who gets to make that decision. So whose discretion is it? And we'll touch on that in the case study as well. So I'm going to hand over to Jess just to discuss the last few key issues. And then we'll touch on the case studies and we'll answer the questions that we've been asked. Thanks, Jeff.
Thanks, Kathleen. So another very practical key issue that we wanted to highlight is around record keeping. So specifically what records you are required to keep from a governance perspective, and then the implications of not doing this. So firstly, the ACNC requires registered charities to keep appropriate records. And the list that we're talking about today isn't exhaustive by any means, but specifically relevant to your governing documents and procedures that are taken pursuant to your governing documents, like board meetings and members' meetings. The church should be keeping accurate and thorough records of board meeting minutes, board resolutions, members' meeting minutes and resolutions, and also an up-to-date membership register. Now, the ACNC guidelines provide that charities can keep these records in whatever format they choose, so whether that is hard copy or electronic, as long as they're easy to find. So you are free to develop your own systems and processes around this as long as it's streamlined and those records can be accessed easily. The records should also be kept for at least 7 years, and they must be kept in English or a form that can be easily translated to English. So aside from complying with your ACNC obligations around record keeping, practically speaking, when we go to make any structural or governance changes, such as amending the Constitution, or if a dispute arises in some context relating to governance, it can be extremely hard for us to resolve issues if the records of meetings or if the church's membership register isn't up to date. So practically, board meeting minutes should be quite thorough. They should be circulated to board members prior to the next meeting and then formally accepted as accurate at the following board meeting, and the same procedure should apply for members' meetings, and that will all be set out in your constitution, or if it's not, it probably should be. And if this isn't done, it can jeopardise your ability to rely on those records as an accurate record of events down the line. Also, out-of-date or just non-existent membership registers are a really common issue that we come across, and it can have very challenging practical implications, particularly when disputes arise, and it's important to be able to identify your members to then determine what rights flow from that. And that's an issue that we'll be exploring in more detail in our case study later on. So the next issue that we want to highlight, which is sometimes overlooked, particularly in older constitutions, but we tend to address as a matter of course in our practice, is dispute resolution and how disputes will be handled when they inevitably do arise at some point. So generally, constitutions will have provisions that deal with disputes that may arise involving members or directors. And as Kathleen was saying before, that may arise involving members or directors. And as Kathleen was saying before, there'll generally be provisions in the Constitution which may require them to be, which may address disputes which require them to be removed or dealt with in some way. Although it's always a good idea to review these provisions from time to time. And again, this is something that will be highlighted in our case studies shortly. But in addition to this, we have started to include broader dispute resolution clauses in our church constitutions, which address disputes that may arise and how these will be resolved. And in particular for our ACC church clients who are transitioning to that corporate model that Kathleen discussed, so a company limited by guarantee, we have a standard dispute resolution clause which has been approved by the ACC National Executive, and it provides an additional step allowing disputes to be escalated to state executive for resolution. So essentially that clause provides a tiered dispute resolution process. So firstly, disputes that can't be resolved between the two parties are escalated to the board for resolution, unless either the senior pastor or a director is actually a party to that dispute. Then when the dispute does get referred to the board, they need to ensure that each party has an opportunity to be heard before a final decision is made on that dispute. And then finally, any dispute which actually involves the senior pastor, a director, or the board as a whole must be referred to the state executive for resolution. And the state executive also needs to ensure that they provide both parties with that right to be heard before a decision is made. So that standard clause that we've started to use in ACC constitutions picks up a number of issues that are important to dispute resolution in general, but particularly in the context of a company structure. So firstly, there is a degree of impartiality to that decision-making process. So the board acts as a third party to resolve any disputes, except where a director or senior pastor is actually involved, in which case the state executive steps in as that impartial third party to make a decision and resolve the matter. So that impartiality is important from a procedural fairness perspective, which we'll also address in our case study shortly. In general, dispute resolution clauses will also include a provision regarding the confidentiality of the dispute resolution process, and generally restrict who is informed of the issues to the actual persons involved in the dispute and the board, and of course the state exec if they are involved as well. The clause should also include some provisions for how a decision will be communicated to the relevant parties involved, ideally the timeframes that this decision and communication process will be conducted in, and also how that decision will be enforced by the board or the state executive once it is made, including whether there is any review or appeals process. Did you have anything to add to that, Kathleen?
Yeah, it's just all that she said is really good, and I think it's really important to get your mind around what process you want to follow when a dispute is raised, because I guess the primary intention of having this in your constitution is to promote a conciliatory approach rather than a litigious one, because the only alternative, if you haven't set this out in your constitution, I guess, is to meet in court, and that's certainly not our preference.
Absolutely. We certainly try to avoid that, and in my experience, particularly working in our litigation team and the other lawyers in our team, I know that so many of the disputes that we see come out of non-compliance with governing documents or improper compliance with the various processes that are set out in those documents, such as expulsion of members and directors. So having those processes really clear in the constitution in the first place and then following them carefully is really the best way that we would see to avoid those disputes ending up in court down the line. Now the final and very quick last key issue that we want to raise was in relation to alterations or amendments to your governing documents. So the process for that will ordinarily be built into the existing documents, or in the case by company, limited by guarantee set out in the Corporations Act. So I won't get into that actual process today because that's something that you're probably already aware of, or if not, you can check your governing documents to see what they actually provide for. But there are a couple of issues that we frequently come across regarding alterations to governing documents which may be relevant to you. So firstly, we've often seen constitutions for sole member companies where there are mechanisms built into the constitution which just don't work, or they're unnecessary in the context of a sole member company. So for example, requiring the alteration of governing documents to be done at a general meeting of members and a special resolution to be passed, where the concept of a general meeting doesn't actually exist for sole member companies and it's just not relevant. So a review of your governing documents can identify clauses such as this, which are just unnecessary or confusing, and fixing them up can eliminate a lot of confusion when you do come to make any alterations to your governing documents.
And I would say that if you do have that clause with a sole member company, there are ways of working around it, and we can obviously help you comply with those requirements, including preparing minutes of a sole member general meeting. We have done that if necessary, but as Jess has said, it is best to sort of consider, in the case of sole member companies, just removing mechanisms that don't work for sole member companies. The main example of sole member companies is, as I said, the care arm or the church operated schools, where you've got the church as the sole member in some cases to retain that control.
Thanks, Kathleen. It's also important to remember that there are very imperative clauses in your constitutional governing documents for any charity, and taking away any one of them or amending them incorrectly may jeopardise your charity registration or your tax concessions. So all charities must have clauses relating to their not-for-profit nature, their charitable purpose, the use of income and also assets during their operation and upon winding up of the entity. So it's just important to keep in mind that alteration to these provisions of your governing document needs to be done extremely carefully and with very considered advice, so as not to jeopardise your registration or tax concessions. And then the final issue that I would raise here is that we often see governing documents come across our desk which have completely unnecessary clauses left over from times when they might have been relevant, but actually today they just add more compliance burden to the church. So a really common one that we've raised on screen there is a requirement to notify the ATO of any changes to your governing documents. Now that was formerly required before the introduction of the ACNC, but now that's completely unnecessary. However, the issue is that charities must comply with their governing documents for continual eligibility for their registration as a charity. So despite the fact that it's no longer required that you notify the ATO of any updates to your governing documents, and in fact you must notify the ACNC, you still must follow the letter of the law as set out in your constitution to actually effectively make those changes to your constitution. So a review to remove redundant clauses like this is also a measure that should be taken periodically.
Thanks, Jess. I can see that a few people are having trouble hearing. Just let us know perhaps in the next minute or so if that hasn't improved. Thank you.
All right, so now we're going to turn to one of our case studies. Now this is a case study that we've prepared for the purposes of today's webinar, and this is loosely based on a number of matters that have come across our desk in recent times, and of course de-identified to ensure that we preserve client confidentiality. But I think this highlights the importance of both effective constitutions in terms of inclusion of key provisions that actually serve the purpose of the church, and also the importance of being aware of your membership. So who your members are, whether they have formally applied, whether they're included on a membership register, and once those questions have been addressed, what rights do those members actually have? So the facts of this matter were that the church came to us for a routine review of their constitution. We would always recommend reviewing your governing documents frequently, and in this case the constitution that the church was using was about 5 years old, and they were keen to make sure that no updates were required. It was a company limited by guarantee, as many of our ACC church clients are, and registered as a charity with the ACNC. So through that review process, we started asking questions about the church's membership, and it quickly became clear to us that this church believed that its 6 directors were its only members. So it had that closed membership model that Kathleen was talking about earlier. Now in some circumstances that does occur, but for a church it's a little bit uncommon. Now there was no suggestion that all congregation members were members of the company, and that's an important distinction for all churches to be aware of. And the Constitution did set out some fairly strict criteria for membership. Now the Constitution also provided that the board can cancel a person's membership if it was of the opinion that the member no longer met the criteria for membership as set out in the Constitution. In terms of procedure, the board could do this with giving 7 days written notice to the member and giving the member an opportunity to address the board meeting at which their cancellation would be considered. Now through this process, it also came to light that 3 of those 6 directors had a falling out with the church sometime before they came to us for advice.
Just hold on 1 second.
I'm just going to try and address some sound issues, so I'll just pause for a moment.
Right, do drop us a note if you're able to hear us again. We've just refreshed it from our end.
So as I was saying, it also came to light through this process that 3 of those 6 directors had a falling out with the church sometime before they came to us for advice. So they hadn't attended the church in some time and had in fact moved and were more or less uncontactable, but no steps had been taken to remove them as members or directors. Now this presented a few problems for the board moving forward. So naturally, the church wanted to remove these people from membership, given that they no longer fit the criteria as set out in the Constitution. Additionally, the consequence of having half your members being absent meant that when an EGM or an extraordinary general meeting of members was called to adopt a new constitution on our recommendation, the required 75% of members to pass that resolution would not be present to approve the adoption of the new constitution. There were some challenges here. So if the members could be contacted and came to the general meeting, it was likely that they would object to the new constitution being adopted, given the state of conflict that existed at the time. In our experience, changes to the governance structure in times of any conflict on the board or within the membership needs to be considered extremely carefully because we have seen that lead to significant disputes within the church. However, on the other hand, if the Constitution wasn't adopted by 75% of the members, it wouldn't be valid and therefore prone to being contested by an aggravated member down the track. So coming back to the issue of members, despite the fact that a membership register didn't exist, the board was confident that all directors of the company at all times in its history had also been admitted as members. It was also unlikely that when the directors resigned, their membership terminated, and certainly the provisions of the Constitution required that members would only be removed by the board when they resolved that the member no longer fit the criteria for membership. And that's unlikely to have occurred in relation to past directors of the company who had simply resigned as directors when their term had expired. So that was the factual scenario that we were left to address, with the ultimate goal of removing these dissenting members from the membership of the church and adopting a new constitution with, amongst other changes, which would clarify the procedure for removing members in the future. An important issue to balance that is of procedural fairness to members, or the principles of natural justice that must be afforded to members. So particularly in circumstances where there's disquiet or conflict in the membership, that's a really important consideration. But really it's something that churches need to keep in mind at all times, because failure to provide your members with natural justice when it comes to their membership could be the root cause of future conflict, as we've unfortunately seen in the past in a number of matters that we've been involved in. And that, of course, also feeds into one of the ACC governance standards, providing that the registered charity must stay accountable to its members. So in this matter, the Constitution required 7 days' notice for members to be removed from membership by the board. The issue was that the board didn't want to give the inactive members notice of the decision to cancel their membership because of the risk that that would re-enliven the past dispute. So the board believed that the inactive members didn't intend to return, and they had in fact resigned as directors. But the concern in this regard is that members could make an argument that they're being oppressed as members of the company, which has remedies available under the Corporations Act, which require a Supreme Court application. So obviously we would strive to avoid that for any of our clients. So to resolve this issue, we included a new provision in the new Constitution which did not require the board to notify members of the fact that their membership was ceasing, but in terms of timeframes was much fairer to members and would probably negate any argument that they had not been afforded procedural fairness or natural justice by virtue of the fact that they hadn't been informed. So essentially that new provision that we drafted stated that membership could cease in a number of ways. So firstly on resignation, but also not responding within 2 months to a written request from the secretary that the member confirm in writing that they wish to remain a member, or also not attending the church for a period of 6 months without giving a satisfactory explanation in the discretion of the board. So these were in addition to the usual constitution provisions that a member could be removed if they didn't act in the best interest of the company or no longer fit the criteria for membership. So importantly and finally in this matter, we recommended that after the new constitution was adopted, which contains that provision that a member who hadn't attended for 6 months could be removed, that the church then waits 6 months from the date that the constitution was adopted to remove those members, as opposed to removing them immediately on the basis that they hadn't attended for 6 months previously. So that was a very conservative approach, but we recommended that so that the church could again refute any accusation that they hadn't provided natural justice and procedural fairness to the members in question. So hopefully that's a useful illustration for you of some of the practical consequences that can arise from a constitution that just doesn't fit the needs of the church, and also the practical consequences of not being aware of things like your membership procedures and maintaining a register, and how those challenges can eventually be overcome with careful advice.
Yeah, so I guess on reflection you might need to consider, just as Jess has given an example, are there circumstances in which membership will automatically cease, as opposed to requiring a removal process that would require giving the member an opportunity to present their case. So in that case we certainly preferred having membership automatically cease rather than requiring that procedure of notice and having the members present their case and potentially enliven the issues all over again that had been presumably resolved since those persons who were disgruntled had left. So another case that I'm aware of is one where a constitution required corporate members only, so that is membership being companies rather than individuals. And that was a particularly, I guess, difficult constitution to comply with, where the company only had 2 corporate members, and there was a quorum for members' meetings of 2. So you needed both of those members to be present for the meeting of members to go ahead. In that case, one of the members had actually dissolved, so the company had dissolved, and there was no way of them complying with the constitution, so they're at risk of losing their tax concessions. So those sorts of things, we've run into that scenario, but that could be resolved by establishing a new corporate entity to be admitted as a member so that they could have the quorum necessary to hold the general meeting to amend the constitution. So we can come up with a solution, but really it's always best to just have a constitution that works and that doesn't require something that's incapable of being carried out. So that's the end of our case studies. We do have some questions, so if you'd like to stay on the line, we'd be happy to speak to that now. Please be aware that if you do have further questions and you have to go now, you can email us. So I've just put our details up on the screen. Please feel free to email either myself or Jessica. We'd be happy to respond to those questions and, of course, set up an appointment if you'd like a thorough review of your constitution. So just going over the questions that I've seen, a few of them relating more to the operations of the charity rather than the governing documents themselves, but we're happy to speak to them just in brief. The first question I saw was about purchasing commercial property, whether that is possible for a church to do. So say the church buys an investment property and rents it out, can that be a successful fundraising strategy for the church? And yes, that is the case. So we've had a High Court case called Word Investments, which basically the court found that a charity is capable of conducting a business or an investment strategy where a profit is generated, so long as that profit is applied to the charitable purposes of the charity. Of course, if you wanted specific advice about a particular scenario, please feel free to contact us about that, as our observations in this webinar are not legal advice, as we don't know the full circumstances of that situation. The next question was, what number of members and directors would be recommended? Jess, did you want to speak to that?
Sure. So it really depends on which model that you would like to adopt. Kathleen raised a couple before. In terms of directors, if you have a company structure, there is a requirement that there is a minimum of 3 directors, and too many can complicate things. We wouldn't generally recommend more than 7, 8 or 9, depending on your circumstances. But again, all very dependent on your circumstances. Now, in terms of members, there is no real requirement. For example, with a corporate member, you are allowed a minimum of 1. That obviously gives a great deal of control to that one member, though. And for individuals, there is a minimum of 3 and no maximum limit. So again, just depending on who you want to have control and how much control you want them to have.
That is in relation to companies. So there is a greater minimum for incorporated associations. I believe it's 7. So you do need to have more people on board the management committee for incorporated associations. Again, if you want specific advice about that, please feel free to contact us. But in terms of whether you have a really broad open membership or a tightly controlled membership, I think it just depends on the particular church setting. I've often advised clients to explain, how much control they want to give to their congregation members, and if it's akin to a member of a company, so hiring and firing directors or voting on changes to the Constitution, then you want a broad, open membership, a large membership. But if you want to consult with them, but you don't necessarily want them to have the decision-making ability, you might, as I said, call them something other than a member. But it's possible to tailor that to your circumstances. There was a question on clarifying the meaning of board or member resolutions. At the time of passing a resolution, it then becomes a decision. So that was the question, is it a decision? Yes, so a board resolution is a decision of the board, and a member's resolution is a decision of the membership. And the last question, the benefits of migrating from an incorporated association, I think that should say, to a company limited by guarantee. There is an avenue for changing structure. If you're an incorporated association, you can migrate to a company, but that's it's quite a large area for discussion. But we do have some information that I can send to the person who's raised that question. So we'll make sure we get your details and send you some further information about that. There certainly are genuine benefits for becoming a company limited by guarantee. As you may have picked up through the discussion, it is a more flexible model. It does allow you for more creative membership control, as it's not a member-driven model, whereas an incorporated association is member-driven. So I think that reaches the end of the questions for today. We hope that you've enjoyed this conference, and we thank you for your participation. The next webinar is up on the slide. If you're interested, please follow the link.
Yeah, and a recording will be made available partway through next week, so do check back on our website for that. But yeah, thank you so much for joining us. Thanks for taking the time out of your afternoon. We all hope you have a fantastic afternoon.